Now, let's please keep 531 open. Allow me to do some speed talking and speed reading.
531 of?
Volume 5.31 of the written submissions. First, well, the point-wise answer to my Lord, the Honorable Chief Justice question, then give me 5 minutes to elaborate. Volume 2. So that is the judgment. Please keep volume 2, simple volume 2, which is my written submission at page 4. These two are also keep open. I appear for the state of Tamil Nadu, the only state which went to the Honorable Division Bench, and we succeeded in the order on which now the advisory opinion is sought. If my Lord will keep my written submissions open, in volume 2, at page 4. Now, the point-wise answer to my Lord's queries before I elaborate, because there are two important judgments, the nuance of which your Lordship will profit reading. One, there is, and this is all said by your Lordships in the context of various judgments. No intra-court appeal is allowed. Point 1. Point 2, advisory cannot be a substitute for review. Number 3, 143, not a substitute for hurrah and curative. And no curative obviously filed in this case. Number 4, if my Lord will turn to page 5 to save time of my written submissions, 5 and 6 have an issue-wise delineation of each issue raised in the reference, which para of the division bench decides this. This is extremely important. Lordship will pardon me for saving time, I'm not taking your Lordship may test it by going to any one para. For example, issue number 1, para 434.1, 434.2, 434.7. Directly deal with it in the conclusions. The reasoning is in the earlier paras 180, 185, 187, 189, 194, etc. Just because I don't have time to read them, please assume in my favor that they deal with it exactly. Every issue, barring issues 11, 12 and 14, barring 11, 12 and 14, everything is directly covered. Now, a word on these 3 issues when I come to the nuance then. 11, 12 and 14 do not really arise because 11, if your Lordship will see the issues, is not a standalone issue and the others are peripheral issues. 12 and 14, in fact, not decided because it didn't really arise. They applied the Punjab judgment in the division bench. So, substantially every issue para-wise is covered. Now, the nuance. Cauvery is clearly on point in my favor. But a nuance is added by 2G. Naturally, these two judges, Lordship will spend 5 minutes on, otherwise Lordship will not get a complete picture. Now, my learned friends will rely on parts of 2G, so let me give Lordship the point, which is also my Lord Chief Justice's query, and then read those parts. What happens is, if a bench is hearing a matter, if it decides to refer by taking a view on 145.3, it can refer, no problem. If this bench decides the matter and chooses not to refer despite a submission in para 34L by him, then, in an appropriate subsequent case, unrelated to this case, unrelated to the list between parties A and B in this case, in a matter between C and D in a subsequent case, your Lordship may or may not refer the issue, not the list. However, the A and B decision, where it is not referred, cannot be touched by a so-called advisory view of 143, because that would be subversive of every principle your Lordship follows. Now, another nuance. That is what this 2G made, very fine nuance. 2G says that you can have a different view on the law, which is what my Lord the Chief Justice is asking. So, in a C versus D case, the law may change because your Lordship takes a different view. But same 2G mentions that you will not change the list of the decision between A and B in the first case, even by changing the law subsequently. Now, another nuance, very important. In the present case, if your Lordships allows this the advisory to proceed, your Lordship cannot give, even if your Lordship wants, your Lordships cannot give a judgment. Assume your Lordship allows the advisory, that the A and B, which is Tamil Nadu, A and B in this case is Tamil Nadu, stands as it is, and the law for the rest of the country will be C and D. Here, the nuance, that is one of the 2 words used in 2G, is view of the law and the decision in the case. So, decision of the case, 2G Cauvery 5 judges say, cannot be changed. the view of the law can be changed in a subsequent order. Unfortunately or fortunately, in my Tamil Nadu case, if your lordship is persuaded to take a different view in 143, both the decision in Tamil Nadu changes and the view of the law changes, which is not permissible. Now come to all of those two judgments. Come to Cauvery first. This is the fastest I can do it, but I'll be very fast. 5.14 is the volume. 5417 is the case. Please keep these 8 principles in mind, Malas, because this is important when your lordship reads these two judgments. Otherwise, Malas, these are repercussions. Your lordships is being asked, and let's be very clear about it, without any camouflage disguise, to change the decision, the merits of the decision, the content of the decision between A and B. And not in a subsequent decision, because there is no way your lordships can change the decision in a subsequent decision without affecting this decision of Tamil Nadu. So it's purely appellate, howsoever nicely you may couch it to a 143 court. And that's a very serious, Malas, subversion of Supreme Court discipline, Supreme Court integrity, Supreme Court, Malas, institutional integrity. These are not rules, Malas, made just like that. Your lordship has so many, suppose, Malas, this is wrong. In an appropriate case, your lordship may refer it. A constitutional bench may sit. But the law will not change for the parties who took it to the other division bench. Because that is concluded. It is inter partes. It is final. It is unchangeable unless in review or curative.
Yes.
The entire concept of stare decisis will be completely subverted, Malas.
Where is the question formulated that we should set aside a particular judgment?
Yes.
We are proceeding on the premise, as we are also sitting in appellate court. We know distinction between 143.1.
Yes.
We know the scope of 143.2.
Yes.
We know Cauvery and 2G scan, the distinction drawn. We are not here on 131. We are in within the parameters of 143.1. And the only issue is that whether the questions raised have been answered or not.
So let me answer, Malas, Justice Vikas. Malas, this is the important nuance. The nuance of 2G is that the phrase, it's not my word, it's the Supreme Court words. The decision cannot be changed. The view of the law may be changed. Right, Malas? No, just give me. Now let me answer Justice Suryakant's query. No, just let me answer. My Lord Justice Suryakant says to me that we will not be touching that decision. Unfortunately, Malas, this is one rare case where both the decision of the case and the view of the law fuse. Let me explain that. There is a complete intersection. Your lordships can't do one without doing the other. And if one is prohibited, the other stands prohibited. Your lordship, all the questions except the peripheral ones 11, 12, 14, if answered other than the way in which the division bench answered it, will constitute a change of law, but a change of law also in the decided case of Tamil Nadu. Because for the simple reason, your lordship's advisory law, which is binding, all admit that your lordship's advisory. Once your lordship delivers 143, it's a question directly arising, I'll give the judgment. Your lordship's views, because your lordship is the Supreme Court, I can't seek your lordship's advice to disregard it.
The pre and post constitution principles are well settled.
Yes.
141 or a principle which was earlier to that effect, it is advisory in nature, purely advisory in nature, may or may not be accepted by.
No, Malas, that's not the law. Unfortunately, that's not the law, Malas. Unfortunately, I would say it's not the law because your lordship doesn't give advisory jurisdiction in futility.